Greetings for the day. I'm Mrs. Reenu Dutt, Assistant Professor Law at BBDU. Today I'm going to teach you the topic meaning and nature of contracts. To start with, meaning of contract. A contract means an agreement which is enforceable by law. An agreement consists of reciprocal, that is mutual, promises between the two parties. In the case of contract, each party is legally bound by the promise made by them. So a contract is defined as one that is legally enforceable by Section 2H of the Indian Contract Act 1872. Rights in personam, or rather we say private rights that solely impact two private people entering into a contract with each other, are normally the focus of contract law. So if we move on to the meaning of what the meaning of contract is, the rights and obligation of two or more parties are established, made clear and governed by a legally enforceable agreement known as contract. Contracts are frequently included the commitment to transmit goods, services, money, or any combination of those at a later date. There are several ways that a promise or a contract might form, say by agreement and contract, by standard form contract, by promissory estoppel. How a contract is formed? So basically it is offer plus acceptance, that is equal to promise. Then promise plus consideration, that is equivalent to agreement. Now agreement add on with enforceability by law, that amounts to contract. Now if we discuss about the requirements for a valid contract, so they should be, first an offer should be made, then there should be an acceptance of the offer. Then to enter into a contract, both parties must be competent. Consideration that is legal in nature must exist. So there should be a legal consideration as well. Then there should be free consent of the parties. And there should be a desire to establish a legal partnership, that is a legal relationship. Now the agreements must be unambiguous. It should not be ambiguous. The language should be clear. And a contract cannot be explicitly ruled invalid or void. Some important case laws which we discuss is Lalman Shukla versus Gauri Dutt, Mohri Bibi versus Dharmodas Ghosh, Rose and Frank Company versus Crompton and Brother Limited, Bhagwan Das Kedia and Girdhari Lal and Company, Durga Prasad versus Baldev. These are a few landmark cases which we are going to discuss in other concepts of law of contract. Now what is the nature of contract? To start with, the nature of contract is the area of law that establishes the conditions under which commitments made by contracting parties are enforceable against them. Contract law is unique. A contract is a legal agreement between two or more parties whereby rights are gained on one side in exchange for acts or forbearances on the other hand. Now if we discuss what the nature of contract is, it is the area which establishes the conditions which are under the commitments made by the contracting parties and are enforceable against them. So contract law is really unique. Now if we consider that a contract is a legal agreement between two or more parties and thereby they gain the rights on one side in exchange of such acts or forbearances on the other. So this is how we discuss the nature of contract. What is the nature of contract? This is we're going to discuss next. Now, if we speak about contracts, contracts have occupied a significant place in the regular vocabulary of individuals, especially those that are engaged in various forms of business operations. It is usually understood as a form of understanding between two or more persons by which rights are acquired on the one side to acts or forbearances on the other. Various criteria are required to be fulfilled for transforming an agreement into a contract. That includes an offer and acceptance as well as the promises emanating from these offer and acceptances to the promises that are guided by law, grabbed in obligation which the concerned parties are bound by. So, the nature of contract is the area of law that establishes the conditions under which commitments made by contracting parties are enforceable against them. The contract law is unique. A contract is a legal agreement between two or more parties whereby rights are gained on one side in exchange for acts or forbearances on the other. Thank you for today.